I've already talked about the discretionary exception from subsection A and the proviso, but where did the proviso come from? Well, answering a question from Justice Alito, Mr. Giacomo said,
and I think that's doubly important here because, again, Congress went out of its way in 1974 to go through all the steps it needed to go through to specifically amend the FTCA to say this very affirmative, freestanding thing. If you're a federal law enforcement who commits an intentional tort, we, the United States, not you, the officer, will pay for it to make sure that there's a remedy for the innocent victims of your mistake or wrongdoing.
If the purpose of the proviso was to make sure the United States would be liable for any intentional mistake or wrongdoing by federal law enforcement, how can that not apply here? Mr. Liu argued that the proviso only amended subsection H, which makes sense. But if the intent of Congress was to provide a remedy to innocent victims of federal actions, could that be outdone by another subsection? Even though the proviso specifically states that with regard to the acts or omissions of investigative or law enforcement officers of the United States government, the provisions of this chapter and subsection 1346B of this title shall apply. Seems like the 11th Circuit is trying to undo the law made by Congress with grammatical legerdemain.